Questions?
In overturning the statutory initiative, did they refer to that case in Texas? I think it was McDonald for that autonomy part of it.
I don't recall whether you mean Lawrence versus Texas?
Lawrence, yeah, Lawrence versus Texas.
I don't recall whether they cited Lawrence. They mainly were citing California cases. Remember, this it's very important. The attack on Proposition 22 was made under the California Constitution, and they could have attacked Proposition 8 in the California State Supreme Court under the federal Constitution. The strategic decision was made by the people who opposed Proposition 8 not to do that, because they didn't think the time was ripe to bring that matter to the fore, because had the court ruled that it was on the basis of the federal Constitution, and this goes back to the question whether it was a revision or an amendment. Let me go back. Once Proposition 8 passed, the people who opposed Proposition 8 had a choice to make. They could go to the California State Supreme Court and oppose it solely on the basis of whether it was an amendment or a revision, and that was a loser from day one. I mean, that was a loser from day one. And if you want to talk about that, we will. I mean, it's kind of history, but. Or they could have gone in, as has happened in the past, and go to the California State Supreme Court and say, we want you to strike this down, this constitutional amendment, which obviously cannot be unconstitutional under the state constitution anymore, under the federal constitution. And that has happened in the past. The initiative that repealed the Rumford Fair Housing Act was stricken down on that basis. Strategic decision, they didn't want to pick that fight now. They didn't want it to go up to the United States Supreme Court, because that's where it would be headed if, in fact, that was the decision. And there was a great deal of controversy within the people who opposed Prop 8 over Olson and Boy's decision to file a lawsuit. Again, it's very important to understand this. We all here today, if we're all billionaires, we could go out and hire a lawyer or lawyers and start a constitutional case and go out and hire experts, and we could decide a major area of public policy outside of the democratic process.
Right.
Happens all the time. Yeah.
I have a very elementary question. Does the state have the right to define human nature? I mean, it starts at the very beginning with the California law. Anything is open really under that law. If I understood you correctly, you can really argue that same-sex marriage or any other kind of what you want to call marriage is constitutional under the California regulations. I feel here they define before. You said they don't. I think they never ask the question about human nature. What does a family constitute? Is a constitutional family? Can the family be made up of two same-sex people, or more same-sex people, or more?
Well, that's exactly what they hold. Not only that, if you want to go out and find somebody who's prepared to assist you in procreating a child, you have the constitutional right to do that. Now, do they
Does the state have the right to define that?
Well, I don't think so. Under the natural law, no. But under the state has the state has to. Let's take it one step at a time. That's why I think our friend Tom Aquinas said that some laws aren't laws. An unjust law is not a law. Okay. So on that theory, no, they don't have the right to say that it's constitutional or legal for a people to allow children to be literally born bereft from the very beginning of their existence of their parents intentionally. No, that's not a law, in my opinion. Now, does the law ever actually sit down and delve heavily into philosophical anthropology? It would have to be philosophical, because the law is an ordinance of reason for the common good promulgated by one who has care for the community. It's not an ordinance of faith. The answer is, if you in fact read this case, and when I give a lecture like this, it's difficult how far we want to get in the weeds with a mainly lay audience. can divine, you can bring out of it their vision of the human person. The human person is a monad that exists in society with no final end other than that which they define for themselves, and that the purpose of society is to, on certain issues, allow as free possible reign of personal autonomy as possible. Now, would Ronald George be able to teach Steve's course on the philosophy of the person? No, but they have a I think that's their view. Does that answer your question?
Yeah, it does. But
Okay.
in other words, I still think, it's wrong. It is simply wrong to allow state aid. And I don't know how does the California Constitution stand to the United States Declaration of Independence, which defines the rights coming from God. Which has an anthropological statement.
You are not, okay, let's take it one step at a time. The most you're going to get, I think you're asking the following question. Would it be possible to take, for example, take the issue of domestic partnerships, that these constitute the same relationships as heterosexual couples? Would there be a basis in constitutional law, federal constitutional law, to make that argument to the federal court and ask the federal court to strike down the Domestic Partnership Act? Is that what you're asking?
Yeah, I'm more on the philosophical side because I think this is so basic and so elementary.
Oh, I agree. I agree. But welcome to our world. I mean, we treat the unborn as non-persons. I mean, you want a list? I mean, modernity has run amok. There's no question about it, and that's why I don't particularly think that we should keep consigning these kinds of questions to the political, judicial class and the academic elites. Yes, Professor Corrigan.
As you quoted the state Supreme Court's reasoning, it occurred to me that I might substitute, wherever they talked about same-sex couples, I might substitute the term polyandrous couples or polygamous couples.
Yeah.
And the reasoning would stand, as far as I can see, unchanged. Do you see anything in the court's reasoning to exclude the possibility of a California constitutional right to polyandry or polygamy?
If I can find it real quick, I'll read you what they say about that. No, I don't find anything in their argument. But if we take a little bit of break, I'll see if I can find it. But what they basically argue is this: after making an extraordinary, strong, passionate argument almost that history and tradition can't bind us on this issue, they say, don't worry about incest or polygamy because history and tradition will prevent it. And this was pointed out by Marvin Baxter, who's had just a wonderful dissent. He pointed that out. He said, I'm not saying the incestuous relationships are the same as same-sex relationships, but your argument doesn't, and here's the problem. Once you unhook the notion of marriage from its physical reality, where is the line drawn? And the answer to that is that you will be. Here's the two arguments that we're making about that. Number one, there's no political interest pushing them, so we don't have to think about that. Which means that there's no, it's of no significance to us that you may have revealed the inherent fallacy of our argument. There's just nobody has yet to pounce on that and make it a political issue yet. That is one argument, and the other one escapes me right now. The other argument is to make you seem like you're a bigot because you are now equating same-sex relationships with incest.